All right. Well, welcome everybody. It looks like our participants have slowed down to joining, so it looks like we have our full house. My name is Michael Benza. I'm a professor at Case Western Reserve University School of Law, and on behalf of the Masters of Arts in Financial Integrity program and the Financial Integrity Institute at the School of Law, as well as ACAMS, I would like to welcome you to this evening's program. The program is approved for 1 CLE credit for the attorneys who are attending. It is also approved for 1 ACAM CE credit. I will be posting the code for the CLE at the end of the presentation, so you will have that code in order to fill out the form. You also have all the links and information in your materials that you received when you registered. During the course of today's program, the chat function will be disabled for the attendees, but we will be using the Q&A function in order for you to ask questions for our presenter at the, which will be addressed at the end of his presentation. So without further ado, I'm going to turn it over to John Moody to welcome you and to introduce our speaker.
Thank you, Mike. Welcome everybody to this evening's event. Again, you're muted from the presenters and each other, and so just use the Q&A if you have questions. My name's John Moody. I'm the co-chair of the Northern Ohio ACAMS chapter, and I have to give a plug out for our ACAMS Las Vegas here. It's the 20th annual AML conference in September 27th through the 29th. It's a great event if you're able to attend. There's going to be virtual as well as, I believe, some in-person as well. Also want to give thanks to our chapter sponsors, primarily the Case Western Reserve University School of Law in the MAFI program for helping our chapter co-host with this, as well as KeyBank, PNC, MGM, Northfield Park, AML Resource, and the Center for Intelligence Studies at Notre Dame College. So this evening, it's my pleasure to introduce Mr. Dan Stefano. Sorry, Dan. He's a partner at Davis Polk's Financial Institutions and Regulatory Group. If you attended one of our prior meetings back in February, he gave us the round one of this evening's topic for the Anti-Money Laundering Act of 2020. And tonight we'll be learning what we've learned over the past 6 months to what that act means and the direction that we may be heading with it. So Dan, I will give the floor over to you. Oops.
Great. Thank you, John. So what I'm going to a certain extent, talk about some of the substantive provisions that are in the AMLA, just so that everybody's kind of, playing on a level field here. But I do think we have learned a lot in 6 months. We're going to learn a lot more in the next 6 months. But I think that I can share some insights with you as to what is happening and how I think this is going to play out. So before we get into that, though, I want to talk a little bit about the AMLA and what it is and how it came to be. So I'm sure everybody in the room knows that the Bank Secrecy Act celebrated its 50th anniversary last year. And so I think that there has been a growing recognition for some time within the financial services industry, among regulators and among legislators, that the BSA has been showing its age. When it was enacted in 1970, it was aimed principally at criminal organizations and tax evasion. And since then, it's evolved into all kinds of things, right? I mean, it became, a weapon against narcotics trafficking And, after 9/11, terrorist financing, and, now it's gone even further, human trafficking, elder abuse, nuclear proliferation. I mean, you name it, the BSA is aimed at it. And so it's gotten bigger, and I think the demands have gotten greater. More industries are affected by it. But I think what has been happening is that the statute and the regulations were also issued, most of them were issued decades ago, right? I think they've been struggling to keep pace with developments in the market, developments in technology that have impacted the delivery of financial services. And I think we've reached a point where there's a pretty serious misalignment with the overarching BSA AML regulatory framework and what's actually happening out there. And a lot of this is technology driven. And I think what that's led to are gross inefficiencies in the system, and for an example of that, I look at all the time, effort, and money spent chasing down false positive alerts to, eventually reach a conclusion that no SAR needs to be filed, and then having to document that. I mean, that's incredibly inefficient. And the overall costs and burdens of the regulatory regime have spiraled out of control. Another problem is that financial institutions do a lot to assist law enforcement. The information that they provide is really critical. But when they're examined, they don't get any credit for that. You could do the best job in the world of helping a US attorney convict a money launderer, but if you have problems with your CIP program, you're going to get written up by your regulator. And I think this has been something that, at least in the banking industry, banks have complained about for years. And, all this has led to some perverse outcomes. I look at, if you think back 4, 5, 8, 10 years, we had a point where virtually every large bank in the country was under some kind of an enforcement action for BSA violations. Every one. Now, they weren't all public actions, some of them were informal, but they were all under one action or another. Some of the banks weren't so lucky. Some of them ended up with public actions, huge fines, multi-agency actions, and even deferred prosecution agreements. So, it makes you wonder when you have banks, the biggest banks in the country, spending incredible amounts of money on AML compliance, with the outcome being that they're all under enforcement actions. What's wrong with that picture? Another perverse outcome is the whole phenomenon of de-risking. This kind of started maybe 15 years ago with money services businesses, but it's gone even farther than that. And it hasn't gotten better for money services businesses. They have a hard time getting bank accounts. So we have legitimate businesses that can't get bank accounts or have a hard time getting bank accounts simply because the compliance costs associated with those accounts are so high that it just makes the relationship unprofitable. And if they're unprofitable relationships, the banks are going to dump them, and they have. So I think that you've had this recognition building, and the big banks in particular lobbied Congress very, very hard for an AML reform bill to bring the BSA into the 21st century. And I think a lot of the thinking behind it is to make the system, make the regime truly risk-based, so that the compliance resources that banks and other institutions have can be dedicated to the highest risk areas, as opposed to, treating everybody the same across the board. And also, I think another goal of the AMLA is to give financial institutions credit for the time and effort that they spend assisting law enforcement on actual investigations and prosecutions. That's the thinking behind it. Will it play out that way? I don't know. I have to tell you, as somebody who's been hanging around Washington for 3 decades, I know very well that no good deed goes unpunished. And I have some concerns that this may actually end up being something that creates more burden and more cost and not less. And we can talk about that a little bit more as we get into it. Anyway, the AMLA, the way it came into being also is kind of interesting. There were bills that were in the House in last session, last congressional session. The House bill was the Counter Act. The Senate bill was the Illicit Finance Act. And there was also the Corporate Transparency Act that was introduced into the House. Now, the Counter Act and the Corporate Transparency Act were passed by the House, but the Senate never acted on the Illicit Finance Act. And, as recently as probably last summer, I was pretty skeptical that we were going to have any AML reform legislation. But what ended up happening was that on the House side, what was basically the Counter Act and the Corporate Transparency Act were added as amendments to the National Defense Authorization Act for 2020, or the NDAA. And they passed it, and then the Senate passed their version of the NDAA with no AML provisions. But because you had versions of the NDAA passed by both chambers, it went to a conference committee, and the anti-money laundering provisions were in play because they were in the House version of the NDAA. And House and Senate conferees got together, and they passed the NDAA with the AML provisions, which are known as the Anti-Money Laundering Act of 2020. And then it went to President Trump's desk. And President Trump had issues with the NDAA that had nothing to do with money laundering, and he vetoed it. And then on January 1, his veto was overridden. And that's how we ended up with the AMLA. So it's had kind of a tortured history. I think it is definitely a step in the right direction. And depending upon how it's implemented, there's a potential that it could greatly change the way AML compliance is done today. The reason that we don't know how it's going to ultimately affect us is because there is not a whole lot in the AMLA that is self-effectuating, meaning it just happens, by operation of law. I think FinCEN has a dozen regulations that they have to issue, and they have to get them out on a very short time frame. They're all due within 1 year of enactment, which is January 1, 2022. I mean, we're already halfway through 2021. So far, there hasn't been a great deal of movement. There's been some movement. I think you'll see a lot more in the weeks and months ahead, but they're going to be very hard pressed to get these rules out and finalized in 6 months. I mean, that generally does not happen. But that's, I think when we see the rules, that's the point where we'll really know how this is going to play out. And, I give everybody I talk to about this the same pitch. This is real important, particularly if you're a financial institution and you're a compliance professional in a financial institution, or a lawyer, a consultant, whatever you are, you have a stake in this. And, I would encourage everyone to participate in these rulemakings, whether it's themselves directly or their organization or, a trade group, whatever it is. So just what are some of the key provisions? I've got them here up on the screen in the blue box. Beneficial ownership reporting could be greatly changed. And, we'll talk about that a little bit more detail in a minute, but this is basically the Corporate Transparency Act. And these changes are significant. The issuance of national anti-money laundering and counter-terrorist financing priorities came out last week, right? I want to talk about them a little bit too. There are increased Whistleblower Awards and enhanced whistleblower protections. So this statute is clearly trying to incent and encourage and protect whistleblowers to get them to come forward. The definition of financial institution that is in the BSA itself is changed to make clear that companies that provide services involving value that substitutes for currency, like virtual currency, are financial institutions. This is not really breaking new ground. FinCEN has issued a number of interpretations of money services businesses over the years that have made it clear that crypto exchanges and other crypto businesses are financial institutions and they're covered by the BSA, but this codifies it in a statute. So if there was any doubt about it, there should be no doubt now. Penalties are increased for certain types of BSA violations, certain types of AML violations. There are a number of provisions that are going to require FinCEN to study and streamline various BSA reporting requirements, particularly SARs and CTRs. And there are provisions that promote coordination and cooperation among government agencies at all levels. So those are some of the key provisions. I mean, there's more stuff in here that I don't have in the blue box, and maybe we'll talk about a little bit if there's time. But these are significant changes. So can we go to the next slide? Okay. So I'm not going to go through all this, but you know, who's covered by the Act? Just about every financial institution that you can think of is covered in some way. They're not all covered the same ways, right? You know, so like changes to the beneficial ownership rule are not going to affect institutions that are not subject to the beneficial ownership rule, like a money services business. It will affect a bank or a broker dealer though. But really, if you are a financial institution subject to the BSA, which, you know, all these listed entities are, you are covered by the AMLA and you will be affected by it. You know, I mentioned earlier the change to the definition of financial institution. I'm not going to repeat myself, but what I didn't mention earlier was that persons involved in the trade of antiquities are now considered to be financial institutions as well. And FinCEN presumably will at some point propose and ultimately issue a program rule. What's curious is that they didn't include art dealers, because that's another area. I mean, art is very vulnerable to money laundering. Maybe there's a strong artist lobby or something, but arts are not in there, antiquities are. Next slide. Okay. So we talked a little bit about codifying the BSA's applicability to virtual currency. I don't really want to get into that. I won't say anything more about that. But one theme that runs throughout the whole AMLA is a focus on technology and on fintech. And there are a number of provisions that, you know, they're not all listed here, but one of them is the establishment of a subcommittee on innovation and technology within the Bank Secrecy Act Advisory Group. So for those of you who aren't acquainted with the Bank Secrecy Act Advisory Group, or BSAG, this is a federal advisory committee. It's actually, it's authorized by the Federal Advisory Committee Act, which allows the public sector to interact with the private sector on a committee like this. If it's not authorized by the FACA, you can't do it. So anyway, the BSAG is led by the Treasury Department, but it includes all of the federal banking agencies, the functional regulators like the SEC, law enforcement agencies, and private sector representation, trade groups, representatives of industries, you know, banks, broker dealers, etc. It's an interesting group. I was a part of it for 16 years. It's changed and evolved over time, and you know, it's not. I don't think that this subcommittee necessarily is going to move the earth, but it is an opportunity for the private sector to have input in shaping policies that are going to influence how technology is used in BSA compliance. And there aren't that many opportunities like that. So, you know, this is not an insignificant thing. And it's good that this made it into the law. Another provision requires FinCEN to appoint somebody to be an innovation officer. Their job is to support federal and state enforcement agencies and regulators, as well as the private sector, with respect to how to use new technologies to comply with the BSA. So lots of provisions in there that focus on technology. focus on fintech, and it really kind of runs through the whole statute. Next page, next slide. Okay, so I want to talk about the Corporate Transparency Act, what that does, and how this is playing out. So everybody, I'm sure, who is on this call is familiar with the beneficial ownership requirements of the customer due diligence rule, which have been applicable since 2018, so a little over 3 years. And those requirements put the burden on banks and other covered institutions to identify and verify the identities of the beneficial owners of their legal entity customers. What the Corporate Transparency Act is going to do is it is going to set up a parallel requirement for reporting companies. So a reporting company is like a corporation, an LLC, a partnership, et cetera. Really any entity that derives its existence from making some kind of a filing with a Secretary of State's office. So if you're a reporting company, once this law is implemented, it's not implemented yet, what you'll have to do is to provide information on your beneficial owners to FinCEN. The kind of information is similar to the kind of information that banks collect now from their customers that are legal entities. So, name, date of birth, address, identification number. So reporting company, if you're a reporting company, you'll have to provide this to FinCEN. You provide it if you're a new company, you provide it at formation. For existing companies, there's a 2-year window to provide it to FinCEN. And if there are changes in this information, then you have a year to update the information that you provide to FinCEN. And FinCEN's role here is to stand up a database, a national registry of beneficial ownership information. It's not a public database, but law enforcement agencies will have access to it. Regulators will have access to it, and financial institutions will have access to it with the permission of their customers. So there's no requirement that the information in there has to be verified, right? It just gets provided. I don't think FinCEN is going to verify it. I don't know if anybody is, but it's going to go into this database for the use of law enforcement, regulators, and financial institutions. FinCEN is supposed to have this up and running in a year. I don't know where they stand on it. I think they could have reasonably anticipated that they were going to be required to do this, and hopefully they've gotten a running start on it. They could, I don't know if they are going to create a new database or if they are simply going to, add on to the existing databases that they manage, but they don't have a whole lot of time to do it. Now, in order to do this, they issued an advance notice of proposed rulemaking this spring, where they issued a set of 48 questions on how this should work. And it wasn't just the 48 questions. These questions had questions embedded in them. So if you looked at all the embedded questions, it was really close to 100 questions. And I found this pretty extraordinary. Advance notice of proposed rulemaking is sort of like the first step in the rulemaking process. Sometimes agencies they skip it and they just go straight to a notice of proposed rulemaking, but they do the advance notice when they're looking to collect information from the regulated industry before issuing a notice. So I think it's a good thing because it gives the industry a chance to provide comment and feedback before they're faced with a proposal, an actual proposal. And given the number of questions and the kinds of questions that FinCEN asked, it suggests to me that they are keenly interested in hearing from the industry on this, and in doing this in a way that is going to actually make sense, for the industry. So I think that's all good. I think that's very positive. And the next step that we'll see on this will be a proposal. Sometime between now and January, we'll go through another notice and comment period. So there's another opportunity to have a bite at the apple and weigh in on this before the rule is actually finalized. And then after it's finalized, there'll be, a period before it becomes effective. But once we've gone through all that, it becomes effective, we will have this process here, and reporting companies will have a new requirement. But what does this do to the existing requirements in the CDD rule? And I think that is really a good question. There is a provision in the AMLA that requires FinCEN to issue a new reg, issue a revised reg, and make conforming amendments to the reg so that it conforms to the provisions in the AMLA. Okay, that's not surprising. I think that is something that you would expect, but the statute goes further than that. The statute requires that FinCEN rescind virtually the entirety of the existing beneficial ownership requirements in the CDD rule. I mean, the only thing that's left standing is subparagraph A. Subparagraph A is a pretty plain vanilla requirement that says that covered institutions have to have risk-based procedures to identify and verify the beneficial owners of legal entity customers. That's it. And everything else that's in the existing rule, right? All the definitions, the definition of legal entity customer, record keeping requirements, all that's all out the window. That's going to be gone. And FinCEN has to issue this amended rule within a year of the effective date of the rule that stands up the database. So, probably sometime in 2023, we'll see this rule. So it means that at least in the short run, it's going to be business as usual. You're still going to have to comply with the CDD rule, even after the database is stood up. It seems like that's kind of duplicative, and Congress, that's not what Congress wants permanently. I think the idea that Congress had in mind when they enacted this was that the AMLA would essentially get banks out of the position of being the middleman in collecting this information. Okay, I don't know that FinCEN sees it that way. I think there's a little bit of tension there, and FinCEN is going to have to thread a needle when they issue their revised CDD rule. But for the time being, it's going to be business as usual. Now, that is going to create some issues, I think, while the two schemes are operating kind of side by side. Because you think about this now, like if you're a bank, say, and you have a legal entity customer, are you going to use the database? If so, how are you going to use it, right? You can't use it as a substitute for what you're doing now, at least as long as the current CDD rule is in place. You could ping against it. You could test the accuracy of the information your customer gave you. But what if it's not accurate? Then what do you do? And do you have a responsibility to let FinCEN know there's a discrepancy? If there's no explanation, if it appears that the customer has not been forthright either with you or with FinCEN, do you file a SAR? Do you close the account? I mean, you could have discrepancies that are totally innocent. Sometimes things change, and the database could be out of date. But it just seems like all of that is going to create additional work potentially for financial institutions. And then after the CDD rule has been amended, and we don't know what it's going to say, we don't know what it's going to get replaced with, then again, institutions are going to have to confront how they want to use this registry, if at all. And I don't know, the amended rule could potentially say you have to use the registry. I mean, we just don't know yet, But this is potentially, I think, one of the biggest changes that is in the AMLA. I think this is an example of something that was designed to make the life of banks and other covered institutions easier. I don't know that it will, and I think there's a possibility that it will make their lives more difficult, trying to reconcile information they're getting from their customer against information they're getting in the database. Another thing to point out here too, the definitions don't align, right? The definition of legal entity customer does not align with the definition of reporting company. There are many more exemptions from the definition of reporting company than there are exclusions from the definition of legal entity customer. And so, you may have an entity that you have to collect beneficial ownership information on because it's required under the CDD rule, but as a reporting company, that entity is accepted and doesn't have to provide the information to FinCEN. So I don't know. There's a lot to work out here. The definition of beneficial owner doesn't exactly align either. And I think there are some ambiguities in the definition that's in the statute. Anyway, I think this is a lot trickier and a lot less straightforward, perhaps, than people had envisioned. So we can go on to the next slide. I think I covered really just about all of this. Yeah. The one thing I would focus on in the blue box, go back for a second, just go back to the last one. In the blue box here, this is what I was talking about. These are some of the exclusions from the definition of reporting company. So publicly traded companies, no big surprise there. Certain nonprofits, government entities, certain financial institutions. But look at the last one. An entity that employs more than 20 people and filed a tax return showing more than 5 million in sales or gross receipts that's in the United States. Boy, that is an exception that you could drive a truck through. That's going to carve out an awful lot of reporting companies. So there's not going to be any beneficial ownership information to check against on businesses that meet that definition. Okay, now we go next slide. Okay, I think we also covered this. Yeah, I mean, basically, existing entities are going to have 2 years to come into compliance after the effective date. And then if you have updated information, you have to update it within a year. And then for new entities at the time of formation or registration, that's when you provide the information. We can go to the next slide. Okay, so I want to talk a little bit about the priorities. This is very much top of mind because they came out last week. So what's going on here? I think this all ties in with what I had said at the beginning about trying to make the AML, the BSA AML regulatory regime more risk-based and to focus on the things that are of the greatest importance. So the way this is supposed to work is that Treasury issues the priorities, which they've done. 6 months from now, they have to issue an implementing rule that will basically tell you as a financial institution what you're supposed to do with these priorities. And basically what you're expected to do is to incorporate them into your AML compliance program. Not clear how you do that, but that's going to be the expectation. And on top of that, you'll be evaluated on this when you get a BSA exam from your regulator. And I think the thinking behind this is that this would effectively replace the kinds of things that you get examined on now. And if it worked out that way, that'd be great. I mean, you've got the government telling you what the government thinks is important. You focus on that in terms of your compliance program. If you do a reasonable job of it, the regulator is happy, and everybody moves forward. But I think there's a lot of problems, a lot of questions, and a lot of issues with this. So let me start with this. The problem with that theory, the biggest problem in my mind, is that I don't see any rollback of any other requirements in the BSA. So if this is meant to be, a burden reducer and something that will get you focused on, the things that really matter, with the idea that you could spend less time on the things that don't matter as much, well, there's nothing that says those other things don't matter, right? So it seems to me like one concern I have is that it seems like this is an additive. This is additive. In other words, you keep doing everything that you've been doing up till now, and now you do this on top of it. Okay, that's one thing. And then it says you're going to get evaluated on it, but it doesn't say you don't get evaluated on the things that you always gotten evaluated on. Your compliance with the 4 pillars at CIP, CDD, all SARS, all that stuff. So it seems to me like what this has really done is it's overlaid a new set of evaluative criteria upon the existing set of evaluative criteria. So more ways that you can go wrong and get in trouble. And then there's the priorities themselves. Now the veil has been pulled and we see what they are. I'm not gonna go through them. I mean, they cover the areas you think that they would cover. Terrorism, corruption, fraud, etc. I didn't think there were any surprises in there, but the priority is just basic. The priorities are basically a list. They're the things that you would expect would be in there. They're very high level, and the priorities themselves are not prioritized, right? I mean, FinCEN says that there's no particular order with respect to them. So what are you supposed to do with that? I think that the other thing is that the issuance said that institutions, while they're not required to do anything until the implementing reg comes out next year, that they should start thinking about now how they're going to do this. That's probably a good idea. I mean, you probably should start thinking about it now. So I start thinking about, the elements of your program. So you start with risk assessment. So, corruption, human trafficking. I mean, a lot of these things I would think are probably factored in now. And if that's the case, great, because then you won't have that much to do. But you're going to have to document that you considered these priorities. And, to the extent that they're not applicable to you, you probably need to document that too. So again, more work, more burden, I think, to show that. But your risk assessment clearly is going to have to reflect these priorities. I think also, to the extent they're relevant, they affect other areas as well. Due diligence, for example, SARs. I think there's an expectation that FinCEN will see more SARs that are filed in these priority areas, than were filed previously. So, the banking industry really wanted this, and sometimes you have to be careful what you ask for. But now we got it, and you'll have to see how it comes out. This is one where I would definitely pay close attention to it. I'd start thinking about it now, and also, stay engaged in this rulemaking, because it's going to be very important going forward. Just keep my eye on the clock here. I think I got maybe about 10 minutes just to hit a few more things. On this page, I don't think that the AML resource sharing is really that significant. A few years ago, the banking agencies and FinCEN put out a document, encouraging banks to do this. I don't think this happens very much. I think there are operational reasons and privacy reasons, confidentiality reasons that make it hard to do this kind of sharing. But this is written into the law, so financial institutions have the blessing of the U.S. government to share resources where they can. Lots of provisions in the AMLA address information sharing. So you see FinCEN, AML, threat pattern, trend sharing. So the idea here is to push down information, patterns, typologies, so that your program is armed with this information and can use it. There's a requirement that Treasury do a review of existing BSA regs. I don't know that they've done anything to implement this. It's a great idea. A lot of these regs are old. A lot of them are outdated. A fresh look, I think, is something that is very much in order. And then this last bullet here, I think, is really important, because oftentimes there is a disconnect between what you hear from policymakers in Washington at the top of the agency and what actually happens in the field with the examiners. And if the AMLA does result in a significant change in the way AML compliance is conducted and measured, the examiners have to be on the page with this, and so we go back to the priorities, right? I mean, if the focus is going to be on how well you are meeting these priorities, then that has to be reflected in the procedures in the FFIEC manual. If you don't change the procedures, nothing changes. It's going to be do all that plus this. Anyway, the requirement is annual BSA AML training for all examiners. We can go to the next slide. Okay, I'm not going to spend much time on this. Talked about it a little bit. The idea here is that Congress is trying to encourage whistleblowers to come forward. So they basically do it in two ways. They provide some incentives. So if you provide original information to your bank or the government, and it results in some kind of a monetary reward of over $1 million, you can keep up to 30% of that. So that's gonna incent a lot of people. It's also going to inspire, I'm sure, a cottage industry of lawyers who are going to want to work with whistleblowers and then get their cut of it. That's certainly what happened with with the SEC whistleblower provisions, which they're laid out here. I'm not going to go through them, but there are some areas where it is comparable, and some areas where I think it goes even beyond what the SEC is doing. We go to the next slide. This just lists some of the protections. Basically, if somebody blows the whistle and they're retaliated against, that the whistleblower has a right to file a complaint and relief, including reinstatement, damages, etc. Go to the next slide. So we talked a little bit at the beginning about penalties. This part is self-effectuating, right? So if there are repeat AML violations, there's a multiplier effect for FinCEN penalties enforcing the BSA. So if it's a situation where there are repeat violations, the penalty could be as high as 3 times the amount of profit gained to the institution or loss avoided as a result, or 2 times the statutory maximum amount for the violation. I don't know if this is needed. I think FinCEN had all the authority that it needed before to assess big penalties, but this will just bolster that. And this also does not affect, by the way, the penalties that would be issued by the banking agencies or the SEC. This is just BSA violations brought by Treasury/FinCEN. There's a clawback provision in there for certain bonuses that are paid if like a director, partner, officer is convicted of violating the BSA. So that means criminal conviction, not a regulatory type violation. Report on deferred prosecution agreements. I don't know that any of this has happened at all, and I don't know when it will. And then the last thing, there's a ban on a person who commits an egregious violation of BSA, whatever that is, from serving on a corporate board of a financial institution for 10 years. Okay, go to the next slide. All right, so there's a lot of other stuff here that we can touch on in our remaining time. No action letters. FinCEN was required to conduct an assessment and make a decision whether it should establish a process for no action letters. They decided last week, they did their study, they did their assessment, and they decided that they're going to proceed with this. I don't know in reality how useful this will be. This will require a financial institution to come forward and say to FinCEN, hey, we're doing this. Can we get a no action letter from you? What if the answer is no? That sounds a little bit perilous. You've kind of laid bare, whatever it is you're doing. Or maybe more realistically, it's this is something we want to do, and will you give us a no action letter if we do it? Some of the problems with this that might make this somewhat less effective. One is timing. FinCEN is a small agency. They got about 300 employees. They got an awful lot on their plate. They generally don't turn requests quickly. And if they don't, if you make your no action, if you submit for a no action letter and you have to wait two years for it, I mean, the parade may have passed you by at that point. So it won't really matter. The other sticking point with this that I see is that a FinCEN no action letter is not going to bind a functional regulator or a banking agency. They have their own source of their independent exam authority, independent enforcement authority. So if FinCEN says, yeah, you got to pass from us, go ahead. It doesn't stop the OCC, from coming forward and, issuing a cease and desist order or civil money penalty. And I think it's unlikely that they will be able to get the banking agencies to join on a no action letter. But for this to really be effective, that's what you would need. You'd have to make sure that the primary regulator is also on board with the no action. And I think that's a tough hill to climb. So I don't know. I guess it's good they're pursuing it. I just don't know how much impact it'll really have. The next bullet is is very important. We haven't, not a lot of movement here, but basically FinCEN was given a year to study existing reporting requirements for CTRs and SARs. And the idea is, how do we streamline this? How do we make this less burdensome? How do we make this less costly? So, some of the things that I think that are on the table are the idea of like, I don't know, like bifurcated SARs, like SARs, you could have like, the regular SAR for the more serious types of crimes, maybe a SAR light, for something that's, where you don't have to fill out all the fields. I think that would be good. I think automated SARs, where this is already happening to a certain degree because the OCC issued a interpretive letter allowing national banks under their supervision to use automated SARs with respect to structuring. That's significant because about 40% of the SARs in the database are for structuring. So you could kind of pre-populate a lot of the fields, and that would cut down on some of the burden of filing structuring SARs. Anyway, I don't know what else they'll come up with, but they've got a year to think about it and report back. And then, every 5 years for the 10-year duration period of this provision, they need to like refresh that. One thing I don't think we'll see is any change in the dollar thresholds. I know the industry would like to raise them. Their point being that CTR thresholds were $10,000 in 1970 and they're $10,000 in 2021. And $10,000 in 1970 dollars, I mean, that would be a much higher figure if you factor in inflation. On the other hand, we are increasingly a cashless society. So a $10,000 cash transaction, I think, is still significant. But the real reason why I don't think you'll see a change in thresholds is law enforcement's against it. And, I think it's very, very hard for FinCEN, whose main constituency is law enforcement, when they're saying that, we don't want to give up anything. We don't want to give up these small dollar SARs. We want all the CTRs. When your constituency is telling you that, it's hard to fly in the face of that and say, well, we're going to raise the thresholds anyway, right? It's not going to happen. So thresholds, I think I don't think those get changed. Okay, just a couple minutes and then I'll stop. Allow some time for questions. The FinCEN exchange, this is a memorialization of something that's been in place for a couple of years. It's a voluntary public-private sector information sharing partnership. I think it's a good thing. I think anytime you get the public sector, talking with the private sector, I think that's good. And it's a chance for the private sector, again, to provide some input and, shape AML policy. Lots of provisions on coordination with other agencies. I don't really want to get into that. The last thing I do want to talk about, though, this is another information sharing provision, is this pilot program on sharing SARs with foreign affiliates. I don't think there's been movement on this yet. I mean, there's probably stuff going on behind the scenes on this and a lot of other things, but the requirement is that in a year, now within 6 months, Treasury is required to issue rules that will establish this pilot program that will allow financial institutions to share SARs within their organization with foreign affiliates. Presently, they can't do that, right? They can share it with domestic affiliates that themselves are subject to a SAR requirement. So, foreign branches, subsidiaries, affiliates in other countries, they'd be able to share them. And I think it'd be interesting to see how they roll this out, whether there's like an application process with it. I mean, I don't know that it's going to open the floodgates and let everybody just start doing this. They could, though. I think this is also a baby step forward towards maybe loosening some of the restrictions on SAR sharing, which I think would be a good thing. But there are some. It's not completely open here. Like, for example, if your foreign office is in China or Russia or some sanctioned jurisdiction, it's going to be off limits and you're not going to be able to share a SAR. So I think by my clock, it's like 7:51. And I think I'll stop there, and I'm happy to take any questions anybody has.
So Dan, one of the questions we have here is, beyond the industry and the legislative concerns, Another reason the BSA needed to be reformed was because of increasing policymaker demand for foundational financial intelligence to support a range of national security politics and policy. I think that was intended to be policies and programs.
Yeah.
They recognized FinCEN could do more in this law to help do so.
Yeah, I mean, the BSA generates a lot of useful information for law enforcement, primarily, right? It generates some information useful for intelligence too, but I think its primary benefactor is really law enforcement, and law enforcement will always tell you that the most valuable information that it gets in financial crimes cases are SARS and BSA reports, you know? So that's kind of the main thing. But in spite of that, when you look at the overall effectiveness of the BSA, I mean, it's not only become kind of inefficient and costly, we are capturing really kind of the tip of the iceberg when it comes to illicit activity. And I think that is another purpose of the AMLA, you know, is to not just make the BSA more efficient, but also to make it more effective. So I think, you know, all of the constituents of BSA information, you know, whether it's law enforcement or intelligence, presumably will benefit from some of these changes.
All right, another question we got is, what's the rationale behind congressional oversight of the DPAs?
Well, I think the idea is that there are certain senators and congressmen that think the Justice Department's going easy on wrongdoers. And I think a lot of this stems from some of the big AML cases from the 2010s, you know, HSBC, JP Morgan, Citibank, you know, huge fines, you know, hundreds of millions of dollars. No, you know, no criminal sanction, you know, no criminal sanction against the bank, nobody goes to jail. And, you know, I remember when I worked for OCC, and, you know, I was called up to testify about HSBC and some of these other cases. That was always a question we would get, because, you know, how come nobody ever gets criminally convicted for this stuff? So I think that's what it is. And, you know, by the way, there is a reason why national banks, or really all banks, have never been convicted of money laundering. You know, that includes HSBC. Because if you are a national bank and you are convicted of money laundering, the OCC has to have a public hearing to consider revoking your charter. So, I mean, could you imagine in the wake of the financial crisis, say if JP Morgan Chase was convicted of money laundering and the OCC had to have a public hearing to consider revoking JP Morgan's charter? I mean, it was unthinkable then, it's unthinkable now. And, you know, so I'll tell you just off the cuff here a little bit, but like, I mean, there were definitely prosecutors that would have liked that outcome. I mean, they wanted to pursue criminal cases, but we told them, like, look, you guys can do whatever you want. We're not going to influence you, but just understand that if you criminally convict this bank, we're going to have to have this charter revocation hearing. And they were like, oh, we don't want that. We don't want to be responsible for the, you know, collapse of the, you know, the global economy. So they default to a deferred prosecution agreement. With state banks, it's not a charter revocation hearing, but the FDIC would have to have a hearing to consider like rescinding their deposit insurance. You know, same outcome. It's the end of the bank. You know, so that's why you have so many deferred prosecution agreements. It's the path of least resistance. And you know, I think Congress feels like, well, they're getting off easy, so we want to, you know, have an oversight over this.
Okay, another question we got is, do you feel the priorities will cause overcorrecting, overfocusing in terms of what financial institutions end up spending resources on and the filing of SARs?
I think it could. I think, you know, it's funny because it's almost like you've got a spectrum here, but like, you know, one possible outcome is it doesn't really change much of anything, right? Because I mean, these priorities are so high level, and they're probably things that, you know, institutions take into consideration now. On the other hand, I think all banks and other financial institutions are so risk averse when it comes to the AML that they may overcorrect on this stuff, you know, and you know, what you might start seeing are just deluges of you know, SARs, you know, that are linked to the priorities in some way. I mean, I think, you know, really neither outcome is desirable. You know, you probably should land somewhere in the middle. But I think that banks and other institutions are going to watch this closely and see, you know, what does FinCEN say about this when they issue their rule? What do the banking agencies say? You know, will there be some FAQs on this? I mean, I think from FinCEN's perspective, at least, just reading between the lines, I think they're trying to be reassuring to financial institutions. I think they're trying to tell them, like, look, you know, you guys are, you know, doing a lot of this already as it is, and you know, this is just a new regime, and you'll get credit for, you know, all the good things you're doing. I'm not sure that bank examiners are on the same page with that. I guess we'll find out.
Okay. Hopefully the training will help out on that piece.
Yeah, hopefully.
Next question we got that came in is, what happens if FinCEN fails to meet its deadlines for their analysis or the fact-finding requirements under the AML Act?
They'll have to send somebody up to the Hill to testify before a congressional committee and get yelled at. I mean, FinCEN, you know, has a long history of not meeting deadlines. You know, I mean, just for some examples, they've been required since 2003 to put out a rule on reporting cross-border international wires. No final rule. You know, they put out a proposal in 2015 for program requirements against applied towards registered investment advisors. No final rule. You know, the gap rule for you know, requirements, BSA requirements for banks that lack a federal functional regulator. I think that proposal came out in the early 2000s, and the final rule came out last year. So I'll make a bold prediction here that FinCEN will not meet many of these requirements. They probably won't meet most of them. And, you know, either the director or somebody who reports to him is going to have to go up to the Hill and get yelled at by senators and congressmen.
Okay. Last question we had that came in, and I'll just read this. Yes, there is the movement on the pilot program mentioned. It's going to be a whole of government review in the registry for financial institutions who want to participate in the program.
Okay, that's good. That's good to hear. You know, I think this is a good provision, and particularly if it lays the groundwork for broader sharing of SARs within organizations.
That's all the questions we had. The only thing, you know, I think I would add is it does bother me a little bit, you know, how much of this is going to be do the business as usual that you've got and add this on. And then by the time you do that, how do you build your risk assessment around all these different things that you're doing?
Yeah, I don't know. And again, I think what really matters is the interaction with examiners, you know, for banks, you know, because you know, if they take the view that, you know, if you're considering things like, you know, human trafficking and fraud and corruption and, you know, everything else that's in the priorities now, then you know, maybe it's not such a big change, you know. But if this results in, you know, a whole new area of emphasis for the examiners, you know, and my view, having been with the OCC for 30 plus years and in private practice for 5 years, where I represent a lot of financial institutions, you know, no matter what the policymakers say, the BSA is what your examiner says it is. That's what you're required to do. And, you know, so it goes back to that training, I guess, you know, and it goes back to the FFIEC manual and what's in the manual. But, you know, if the policymakers are, saying one thing and the examiners don't get the memo, or don't read the memo, then this could go wrong, So I don't know. I'm probably too cynical. I've probably been doing this for too long, and I've been in Washington too long. But like I said at the beginning, no good deed goes unpunished.
And that's one of my favorites there, that quote. We did have two more come in.
Sure.
The one here is, would you agree that generally Congress is not satisfied with the job FinCEN is doing to date? Appears Congress has tried to get performance by adding FinCEN in work that is traditionally handled by lawmaking and law enforcement responsible to FinCEN.
Yeah, I don't know. That's a good question. If they're not happy, they certainly seem to be expanding their jurisdiction, in lots of ways, although they're not really giving them, the budget that they need to do all the things that they keep tasking them to do, which puts them in kind of a vulnerable position. The other thing too, which I didn't mention, which I probably should mention, is that, with the issuance of these priorities, right, that the bank supervisors have to take into account when they do exams, it is giving the Treasury Department and FinCEN a much greater role in bank supervision than they've ever had previously. So it's like, if there are critics of FinCEN in Congress, it's kind of perverse because they're just giving them more power and more authority, and but they're not really giving them the budget. So it's that's kind of a bad spot to be in. That's like getting set up to fail.
Okay, and the last question that we've got is, any move towards FCPA like strict compliance liability?
No, the BSA and the AML framework is really a different type of approach than what you have with FCPA. And for better or worse, it's a risk. It's more of a risk-based type of system. And the good thing about that is that I think it gives financial institutions some discretion to create programs that are effective for their risk profile. In other words, it's not one size fits all. The bad thing about that is that there's a lot of subjectivity involved in that, and it kind of opens the door towards regulatory second guessing. So but the short answer to that question is no. I think the AML scheme is very, very different from the FCPA scheme, and I haven't heard anybody seriously propose to make them alike.
Okay, and that's all the questions we had. I know this is your last slide, Dan. Anything you wanted to mention on that, or we'll just have it up a minute for the record?
This is our fabulous team at Davis Polk, and please feel free to reach out to any of us if you ever need our services. That's my commercial.
Okay. All right. So thank you, Dan. I really appreciate. I think you did a great job of adding the insights that we didn't have in February, but there's still going to be more to come as we get advance notice of rulemaking and the rulemaking notices coming out. And I really like your point about, we need to stay on top of those when they come out. And if we feel strongly, make a comment about something to keep FinCEN understanding how the business is out there, financial institutions really do the business we do.
Thank you, John. It's been a pleasure spending the evening with you.
Okay. From ACAM's perspective, anybody out there in the audience who's an ACAM's member, please make sure you've got an up-to-date ACAM's profile. That's how ACAM's gets a hold of you, and you get the communications about events such as this one, as well as other chapter event things. If you're a member of the Northern Ohio chapter, make sure that you send any of those changes into our NOH.ACAMS 2014@gmail.com address, and we'll make sure we update our mailing list with any changes you may have had. Looking forward, our next Chapter Mafia event will be on August 26th. We're also planning some additional virtual events for the third and fourth quarters here in 2021. And look for those communications on our upcoming events. So with that, Mike, I will turn it back over to you to talk about the CLE submission and ACAM submission.
Great. Thanks, John. Thanks, Dan. Really informative. I really appreciate you agreeing to do this for us. So I am going to put up here